we now get a legal perspective on the Supreme Court ruling on the Osun State governorship election. And joining us in our Lagos studio is legal practitioner Evans Ufeli. We'd like to thank you for joining us at this time.
Good morning, thank you.
So, tell us, what are your thoughts? First, the technicality. I mean, the court held that the absence of Justice Peter Obiora during the tribunal hearing, February the 6th, rendered the judgment of the trial tribunal a nullity. Many people are arguing, isn't that technical rather than substantive? How do you interpret that?
Well, there are two broad sides to the judgment, for which I'm going to bring a third perspective, a third side to it. Some persons have argued that the judgment is a technical one because one of the panelists, did not partake in one of the sitting at the tribunal, and they said a person was the one who read the lead judgment and all that. And if you look at the question of jurisdiction, it's also hinged on that where a party did not partake in the process and proceedings, it will be wrong for him to, give and all that. So both technical angle and then you have the jurisdictional angle to it. But the perspective I want to share is that the sins of the tribunal ought not to have been visited on the litigants. Okay, because now,
by that,
the sin of the tribunal not putting its house together well, properly constituted, and then not having a particular member of the panel in the proceeding, and then making room for that same person to, give the lead judgment or to read the lead judgment. That is the area where the Court of Appeal came from. And that is what the Supreme Court has affirmed. You understand? So I'm saying that it is a fault of the tribunal. And that sin ought not to have been visited on the litigant. The litigant did not constitute the panel. Okay? So if there's a problem as regards the panel, whatever mistakes they have made or errors, like the Court of Appeal says a patent error, okay? That's the error of the tribunal. Shouldn't have been visited on the litigant. The litigant are the contestants of that election.
Is this leading credence to the fact that the courts are becoming courts more of technicalities rather than of law?
Well, I won't say it's becoming more of technicalities rather than of law. But the part that the court took in this is that is not very favorable to the litigants. Because like I said, the establishment of the tribunal, the process and proceedings of the tribunal, if an error occurs there, such error should not become or should not be visited, should not now be what will affect negatively the litigant in this action. So that's exactly my expression. But when you look at it from the area of technicalities, there is high level of technical justice in this. And there's also a high level of jurisdictional issue. Because once an issue boils on jurisdiction in law, it means that it is fundamental, okay? It is fundamental. And we ought to look at it clearly from the grounds of the fact that whether it is technical or whether it is jurisdictional, the most important thing here is that the sins of the tribunal ought not to have been visited on the litigants, because the litigants are parties who have come to court to seek for remedy.
How would you interpret the fact since the case began, the dissenting judgments right from the trial tribunal? I mean, some judges taking a position, of course, majority in each step, talking about the trial tribunal, the Court of Appeal, and even the Supreme Court, two-side dissenting judgments. Yes,
at the tribunal it was 4-2, okay? And then the major issues there were the issues of the rerun, okay? The areas affected where they conducted the election, where they conducted another election, and then what transpired there. And then there were allegations of non-compliance, substantial non-compliance with the Electoral Act. And all these allegations were all the basis upon which the tribunal gave the said judgment, okay? And when the case moved from the arena of the tribunal to the Court of Appeal, The Court of Appeal then did not look graphically into the merit and substance that has to do with non-compliance with the Electoral Act, substantial non-compliance with the Electoral Act, issues of rigging, issues of vote buying, and then thuggery and brigandage. That was not looked into. The part where the focus on was the fact that the person who led or who read the lead judgment was not in the proceedings on a particular day where evidence were tendered.
You're a key witness.
Yes, so that is the thing, that is what but that is the decision of the tribunal and not that of the litigant, okay? And then when you moved from there, they went to the Supreme Court, and the Supreme Court looked at it, said that the same issue, that this is a patent error. You understand? And then went ahead to affirm the judgment of the Court of Appeal. I think that generally and broadly speaking, I do not think that they ought to have taken that route by making it look too technical. Okay, yeah. The merit, okay, ought to be looked at. They are supposed to look at the merit of the matter, irrespective of the fact that we have a jurisdictional issue. So that is my position.
All right, we'd like to thank you, Evans Seferi, legal practitioner, for joining us on the program.
Thank you.